Right, people, welcome to part 2 of this 3-part webinar series where I discuss the judgment, this important judgment handed down by the Western Cape Tax Court. Now, in part 1, myself and Hopelang from our office went through the background and the facts that sketches kind of the scene for this discussion. And so if you've missed part 1, it's on the YouTube channel. Go and have a look at part 1. It's not a long video. Have a look. It is important that you go through that to put this into context. So in this part 2, I want to discuss how prescription was dealt with in this case. Now, the reason I'm making such a big deal about this is because there's a principle that emanates from this where the court confirms that the way SARS did it in this case is wrong. And this is a practice that I see in doing dispute resolution all the time, and often dealing with the issue of prescription. The approach SARS adopts here is something that they do all the time, and it's something that I've been saying for years. That is not the right approach. In my book, I've said it in articles published years ago. You'll find the link to those articles in the description below. And here, for the first time, the court is saying SARS is wrong. Now, there's a couple of things about prescription here that the court deals with here. So I just want to go through those, and then we'll circle back, and I'll give you some comments and just explain how this is relevant and what you must take out of this from your day-to-day dealings with SARS, especially in the case of prescription. Right, so you'll recall that the issue, just briefly, is the deductibility of the premium, and the merits, at least, is the deductibility of the premium and the tax treatment of this interest, this notional interest. Now, SARS had to lift the veil of prescription, and you'll recall that SARS had said in their pleadings that not declaring the interest is non-disclosure of material fact, and that claiming the premium as a deduction when it is in fact not deductible is misrepresentation. So the reason they do that is because of 99(2). So just again to remind you, Section 99 says that an assessment that's older than 3 years prescribes, right? In the case of an assessment by SARS, or in the case of self-assessment, 5 years. The fact in this case is assessments by SARS, so I don't want to venture into self-assessments. So 99(1) says in the case of an assessment by SARS, 3 years from the date of the assessment, and then 99(2) creates the exceptions, as we all know. And the exceptions to prescription in the case of an assessment by SARS is that SARS can lift the veil of prescription. In fact, in other words, they can raise an assessment, an additional assessment, despite the fact that the original is older than 3 years. If the correct amount of tax was not assessed in that original assessment due to fraud, misrepresentation, or non-disclosure of material fact. So it is tried law that if SARS wants to lift the veil of prescription, they carry the burden of proof, and they carry the burden of proving two things, right? One is that there was fraud, misrepresentation, or non-disclosure of material fact. Let's call it the taxpayer's misconduct, right? To just sum up those words together. So they must prove that there was misconduct. And then, in addition, they must also prove that it's the misconduct that caused them not to correctly assess the taxpayer. And those two principles are very important, right? So, SARS fires off their attack on prescription by saying that if SARS is saying that if they can show one form of misconduct in relation to one item on an assessment, then they can open up that assessment to effectively to tax anything or to change anything in the original assessment. So in other words, if they can show one issue, one misrepresentation, one non-disclosure of, for example, interest, or one misrepresentation, one thing, they can open up that assessment and change anything. I'll give you my comments on that in a second, and I can't help but laugh about that point. But anyways, I'll give you my comments, right? Right, so now the court says, but there's no merit to that argument. You can't say because there was, for example, non-disclosure of the interest, because it was common cause in the fact that the taxpayer didn't disclose the notional interest of 2,000 Rand, right? But the court says you can't make that argument that the non-disclosure of the interest of one item allows you to open up the entire assessment and change anything in that assessment, regardless of what was not disclosed. And the court goes into the reasoning the court gives for that conclusion. He says you can't, that's not the way it works. As he goes to, I think it's Primaria Renaissance, where the court says, well, clearly there it is shown that SARS must be able to prove that that misconduct, a particular misconduct, caused them not to correctly assess it. So the court says you can't say that non-disclosure of the interest caused me to incorrectly allow the deductibility of the interest, not without more, effectively, right? So you'll have to show that the non-disclosure of the interest caused you not to tax the interest, right? So you can't say non-disclosure of the interest caused me necessarily not to allow the premium as a deduction, this 10 million rand insurance premium. And the course is that's because you must prove that the cause of the misconduct is what caused you. Now, in fairness, and with respect to the judge in this matter and everybody involved, that's right, I agree with that principle. I think that the answer to that more lies in the meaning of the word assessment. And I have been on record everywhere and on many things where I said that the meaning of assessment, the word assessment, is misconstrued all over the place. When you look at section 99, it says, so it talks about an assessment, and an assessment prescribes. And then 99.2 says is that assessment, despite the fact that it's older than 3 years, does not prescribe or SARS can live if that assessment is wrong due to misrepresentation or non-disclosure of material fact. An assessment is a determination, it's one line item, right? It's not the entire notice of assessment. In fact, in HR Computech, the court confirmed that because of First South African Holdings, and AXA has another judgment that confirms that, where each determination, each assessment is a separate, or each determination is a separate assessment, albeit embodied in one notice, it's a separate assessment. So if you want to say that that assessment to interest, although prescribed, I can lift it because that assessment to interest was not made because it was not disclosed, right? So it is a line for line determination, not because that's, in my view at least, not because necessarily SARS carries the burden of proving that the cause of the misconduct caused them not to assess that amount. In my mind, it's because the wording of section 99 clearly envisages that. But nevertheless, the court says, well, you can't go into that argument. And I'll talk about why I think they raised that argument. So the court then says, okay, fine. You need to, because it's a per item kind of exercise, so we have to see, can you lift the veil of prescription to tax the notional interest that you wanted to tax? And could you have lifted the veil of prescription to disallow this deduction of the premium? So we'll look at them separately. The court does add, and it's important that I say this, the court does add that it is not wrong, or it's not improbable or impossible for SARS to say that one particular non-disclosure caused them to disallow, for example, the premium, or not to allow. No, let me rephrase that. The court says it is not impossible for SARS to say that the non-disclosure of the interest, right, the non-disclosure of the interest caused them to incorrectly allow a deduction, and therefore they can lift the veil of prescription, but then they must prove it, and they must actually argue it, and they didn't in this case. I'll circle back to this. So the court says we look at these things in isolation, right, because SARS didn't argue it the way I think they should have, and the way the court ultimately seems to say to them, but you missed the point here. You could have won the case, but you're not arguing correctly. Because he says that doesn't mean, even though it's a per item analysis, it doesn't mean that you can't say one thing caused you to do something else as well. That's fine, but then you must prove it, like in the Spur case, for example. Right, so now having established it's a per item thing, the court looks at the premium and the interest separately. On the premium, the court says there's two things, like I said earlier, that SARS must prove here for them to have lifted the veil of prescription. And the first thing is you must prove that there's this misconduct, right? And the second thing you must prove is that this misconduct caused you to incorrectly allow the premium as a deduction. It says, okay, fine. In this case, SARS failed to prove the misconduct in relation to the premium. I'll circle back to this. This point, that SARS failed to prove the misconduct, is something that they do, in my experience, almost in every single assessment I've looked at on prescription. They raise it in every single assessment where I've disputed it, I've said that's wrong, and here the court for the first time says that's right, and the views I expressed in the book is correct, at least according to the tax court. We'll see if this goes on appeal. Right, so first of all, the court says, SARS, you failed to prove the conduct, the misconduct, the misrepresentation that you're alleging here. You didn't prove that. And further still, the court says, but even if I'm wrong, right, even if I'm wrong to say that SARS failed to prove the misconduct, SARS certainly then failed to prove that there's a link between the misconduct here and them not assessing it correctly. In fact, the court says when I have to go and look into, or when I look into what caused SARS not to disallow the premium deduction sooner, it is not any misrepresentation on the part of the taxpayer. Rather, says the court, it is the compliance auditor's fault for not doing his or her job properly when they did the verification. Because you'll remember from part 1 that SARS pulled this file for verification 4 months after the original assessment, which is well within prescription time periods. And in that process, the taxpayer disclosed to SARS, because SARS in fact questioned exactly this insurance premium. And the taxpayer responded to say this is self-insurance, and they gave SARS all the documents. And then the SARS compliance auditor decided to close the file without any further adjustments or any further investigations. And the court says, if anything, if there's any blame or any cause for SARS not disallowing this premium deduction sooner, then it's because that compliance guy, that compliance auditor, the verification guy, didn't do his job properly or her job properly. And I'll circle back to that because we've got some comments on that. Then, so SARS fails on lifting the veil of prescription in relation to the premium because they failed to prove the misconduct and they failed to prove the causal link between the misconduct and them not disallowing this deduction sooner. On the interest, the court says, I grant you that this notional interest of 2,000 Rand that the taxpayer earned on this call account, sorry, it's not a call account, this premium, right? So this insurance account, let's call it that. Now, the court says, yeah, that wasn't disclosed. That's a non-disclosure, absolutely. But then the court goes on to say, given the quantum relative to all the other expenses and relative to not that there's a materiality number, right? But the court says the 2,000 Rand is not a material non-disclosure. So yes, the taxpayer did not disclose the interest, but it's not a material non-disclosure, and therefore you can't tax the interest. At 3 years is prescribed, it's not a material non-disclosure. Now, right, to my comments, right, on this issue, right. This argument that SARS raises, that if they can lift, that they raise in this case, that if they can prove non-disclosure of one thing, then they can open up the entire assessment, is absolute nonsense. There is, in my view, absolutely no authority to that effect. In fact, all the authority seems to suggest the other thing, right? The contrary. Now, and I can tell you, I can just point to AXA and First South African Holdings and HR Computech, all those cases where the court says, well, assessment is a per line item thing. It's a determination per determination, although embodied in the single notice of assessment. So there's no merit to that. And the only reason I suspect they raised it is to address what is a glaring issue in their case, right? The glaring issue being they've made no case on the premium. They have made no case for lifting the veil of prescription on the premium, right? That's why they raised it. That to me seems like well, it's my suspicion. That is a kind of Hail Mary, let's hope this sticks. Maybe the judge, didn't have cornflakes or something that morning, or cornflakes wasn't nice and he actually buys it. But that to me makes absolutely no sense. And the court, fortunately, sees through it, granted for a different reason than I would have, but the point is it's seen through, because the court says, no, that's not right, because you have to prove that the cause of the misconduct is what resulted in the incorrect assessment not being, or the assessment not being fixed. Now, I say for a different reason. I say it's First South African Holdings and AXA and those things, right? But what the court does, and here's an important thing, right? And I'll make similar, you'll see when you watch part 3, I have similar comments about the way this judgment is written. You get the distinct feeling that the court is saying to SARS, you messed up your case, right? Because the court makes this statement. It doesn't have to, right? Justice, anyway, he doesn't have to, right? He doesn't have to, but he says, even though it's a per item thing, it doesn't mean, SARS, that you can't say that the non-disclosure of one thing caused you not to tax the other thing, or the non-disclosure of one thing caused you to allow a deduction which is not allowable, but then you must prove it. And here SARS didn't even lead any evidence, right? The arrogance is absolutely shocking. It's either arrogance or ignorance. I don't know which one is worse, right? But they lead no evidence to prove it. And here's the kicker, right? Let's get to the premium, because now after the court has dealt with this this issue that it's, or this thing that it's two separate things, right? It's a per item thing that you have to prove per item that it was incorrectly assessed. The court says SARS failed to prove in relation to the premium that they now allowed as the deduction, which they're saying they incorrectly allowed, and they want to lift the veil of prescription. They say that the court says SARS failed to prove the conduct, the misconduct. And here is something that they do, in my experience, in every single case that I've dealt with on prescription, is they will make a statement to say, I can make an audit finding, therefore there was misrepresentation and I can lift the veil of prescription. Because remember what they said here, and in their pleadings, no less. You can kind of get it if it's an auditor that's raising it, right? I probably shouldn't be saying that, but I can kind of get that, right? But in a pleading no less, which says, well, you claim something that's not deductible, therefore there's misrepresentation. That is absolute, in my view, nonsense, right? And the court calls them for the first time on it, and I couldn't have been happier when I read this, because I've been saying it for years in my book and in articles. In fact, I've got a whole article about the Wingate-Pierce judgment, right? The court says here, we need to look at what is it that SARS must do to lift the veil of prescription. Let's talk about this misconduct, right? SARS, by saying that that the taxpayer claims something that's not deductible, that doesn't mean anything. That is, if you want to prove misconduct, if you want to prove misrepresentation, you need to prove the facts, not the law, right? To say that it's not deductible, for the taxpayer to have claimed something that the taxpayer thought was deductible was effectively to take a legal position, right? That's not misrepresentation, that's a position of the law. To misrepresent the taxpayer, if the taxpayer had claimed the insurance premium under repairs and maintenance or cost of sales or something like that, maybe there was misrepresentation, but he put it under insurance premiums in the tax return, and that's where he claimed it. That's not misrepresentation, that's a legal position. Now, SARS must prove the facts, and the fact that there was misrepresentation. By saying you claim something, and I've been saying this for years, they confuse SARS. They confuse the requirements of Section 92 of the TAA for those of Section 99. And I think the Wingate-Pierce judgment has got something to do with that, and we'll talk about the Wingate-Pierce judgment. It's got something to do with that, and the history of prescription in the now repealed Section 79 of the Income Tax Act. There's some history as to why they're doing that. But the TAA, which has been enforced since 2012, which is a couple of years now, right, is entirely different, right? So 92 of the TAA says that SARS can make additional assessments, and there the legislation or the legislator had given SARS a discretionary power to some extent, where he says, or she, or, well, let's just say the legislator said that SARS, if they are satisfied that there's an assessment that doesn't correctly reflect the application of a tax act to the prejudice of SARS or the fiscus, then they may make an additional assessment to correct the prejudice. You can see there that the word is satisfied is in there. SARS's satisfaction is important. And indeed, when you look at Pretoria East Motors and all those things, that is a subject of satisfaction based on reasonable grounds. So they can't just randomly come up with stuff and say, well, you know, I'm satisfied. There has to be reasonable grounds. And then SARS, so there's a lower level, a lower level test, if you will, for raising an additional assessment, that being SARS's satisfaction. However, when that original assessment, which you now have a reasonable and subjective opinion is wrong, is older than 3 years, in the case of an assessment by SARS, then Section 99 kicks in. And Section 99 says SARS now, in addition to you having subjectively identified that this premium in your view is not deductible, to use the facts in this case, you have now subjectively identified that, that's your view. Now, objectively, you must identify the misrepresentation, right? And the court says not a misrepresentation of the law, a misrepresentation of facts, that the taxpayer misrepresents something. And now SARS must prove it. But to say, as they do almost every time, right, that I can make an audit finding, I think this is not deductible, therefore there's misrepresentation, falls well short of proving it. And now here comes a further kicker. What they do in practice, in my experience, is they will, when at the audit level, and I get it, I get the practical reasoning for it, but I don't care, I almost said something, right? I don't care, the law is the law and you must stick to the law, right? As you force taxpayers to, so too must SARS. And granted, they often do, but in this particular space, in my view, is they don't always. I have to be so careful, you know? Anyway, so to say that I can make an audit finding, and therefore there's misrepresentation, defeats the purpose of Section 99. Section 9, and this is a point that I need to get across, especially for perhaps if there's a SARS official listening, which is fantastic because you can learn a lot, right? So the fact that you can make an audit finding does not entitle you to lift the veil of prescription. An assessment prescribes despite the fact that it's wrong. In other words, if the assessment is wrong, you can't change it if it's prescribed. You can only change it if it's prescribed if there was a misrepresentation, misconduct. And further still, for you to have raised that assessment, SARS, you must establish the misconduct at the time of raising the assessment. Not 6 years later when we get to court in your pleadings, you want to say, oh, but there was misrepresentation because of this, that, and the other thing. No. In your assessment, right? In your notes of assessment, section 96 in fact requires that. Because when you think of any additional assessment, you look at section 92, 96, is effectively not fully based on the taxpayer's return. Right? That's why there's an additional assessment. It's not fully based. And so therefore the grounds, in terms of section 96.2, must be in the notes of assessment. And if it's an audit, it must be in the audit findings in terms of section 42. This nonsense approach, where we'll just do an audit, and then we will make a finding, and then we'll say there's misrepresentation, because we can make an audit finding, and so therefore we effectively just ignore section 99, because it's just a thing that's there, and it's annoying, but whatever. Right, so we'll just ignore 99, we'll say we'll make an audit finding, therefore we can lift the value of prescription. Now 6 years later, or 3 years later, or however many days or years later, we get to court, now all of a sudden legal and SARS goes, oh goodness, we actually have to find the facts to prove the objective existence of the misrepresentation. That is unacceptable, right? And that's something that must be raised as a defense. Indeed, it's certainly something I raise in defenses, right? So there's two elements to this. One is, if you try SARS, because that's what they, in my experience, typically will try and do, is they'll say, okay, now we get to litigation. My auditor has alleged misrepresentation on the basis he can make an audit finding, which clearly is wrong, right? So now I'm going to go and ask for information and all sorts of things in the outcome of objection or in the objection process. In fact, I start asking for information because I realize I haven't actually proven misrepresentation. That's too late. That's a breach of the taxpayer's right to administrative action that is lawful, reasonable, procedure fair, in particular section 96.2 and indeed section 42 in the case where the assessment is the result of an audit. Right. Now the reason I said why I think this practice is persisting, one, it's either, well, maybe it's ignorance or arrogance, I don't know. Maybe it's the history. Because indeed the predecessor to section 99, and that's where the Wingate-Pierce judgment comes in, and I've got lots of criticism, respectful criticism on that judgment, but historically, the way the predecessor to section 99 of the TA read is SARS's satisfaction was also mentioned as a requirement for lifting the value of prescription pre the TAA. So it would have said something along the lines of as SARS can lift the value of prescription if they are satisfied that the incorrect assessment was caused by fraud, misrepresentation, and non-disclosure of material fact. That satisfaction, that subjectivity was removed in section 99. Now the Wingate-Pierce judgment, and all the links to this is in the slides, in the description below. The Wingate-Pierce judgment, I think, borders a little bit into a space where it doesn't make sense, or I respectfully disagree with the judgment, where the court says, well, you must read now section 92 and 99 together. So, because when you do that, remember I said earlier that SARS's satisfaction is indeed important for raising an additional assessment. So 92 says if SARS is satisfied that an assessment doesn't correctly reflect the application to the prejudice of SARS, then they may make an additional assessment. The court in Wingate-Pierce brings that satisfaction into 99 by saying we must read them together, right? And I'm in respectful disagreement with that. That doesn't make sense. I mean, and in my article, I don't want to repeat what I'm saying in that article, but I've got an article about that judgment where I go into detail on this, right? But this is important to understand. This is the first case where SARS says, where the court says, no, you can't say that because the taxpayer claims something that you think is not deductible, that's misrepresentation, because that would defeat the purpose. And I want to reiterate the point. An assessment can be wrong and still not be changed because of prescription. And the way SARS seems to look at it is if an assessment is wrong, then that is automatically misrepresentation, and therefore that would render section 99 redundant. That is clearly not the purpose of section 99. The purpose of section 99, which was confirmed, well, it was on the predecessor section 79, the Bermuda Renaissance case, was to create finality. So make peace with this fact that an assessment is wrong and can still not be changed. That is normal. That is what the legislature envisaged. It is only if the assessment is wrong and it's older than 3 years, but it's because of a misconduct on the part of the taxpayer that you can change that assessment. Don't confuse the two and stop confusing the two, or do, then I'll just keep on fighting the cases, right? And for those of you who are sitting with those cases, this is very important to raise correctly, because I can guarantee you, you're going to get strong opposition from SARS to say that's not how it works. Right? Don't just be careful. Make sure you take the right position. I'm mindful. I'm not going to give advice here. If you've got a case that you need assistance with on prescription, we can engage to deal with it. But this is a crucial point that and I've been saying this for years, and I can't overemphasize this issue with 96 and 42 and the point at which the objective existence. I remember I was doing a lecture at one stage, and there was a SARS person in the attending. I don't know for the webinar or something, but anyway. And the person said to me, "But Nico," and I think it was when I discussed the Wingate-Pierce judgment at the time. Someone said, "But Nico, if I go and I look at a taxpayer's return and they haven't disclosed this, that, and the other thing, then chances are there was misrepresentation, and therefore I can lift the valid prescription." No, that's exactly where you're wrong. That's exactly where you're wrong. That's exactly why you're raising these assessments, which I'm squashing all the time, right? Because yes, you might say to me that there's a high chance that there is misrepresentation, but do your job and go and find it and then raise the assessment. Then I won't be able to squash it. Find the misrepresentation and put it in your grounds for your assessment. Not later when we get to pleadings, because what you can't just kind of take a shortcut in raising the assessment and then try and fix it later in appeal. That's a breach of section 96 and 42, right? So this is important. What I think SARS should have done here is, it seems to me, because SARS didn't lead any evidence, right? Which, again, I don't know if that's arrogance or ignorance. I don't know which one is worse. It doesn't matter, right? The fact is, SARS, the court ultimately says to SARS, if you read between the lines, or if I read between the lines, and you read this judgment carefully, you kind of get the distinct impression that the court is telling them what they ought to have said, right? And what they ought to have said, SARS, what they ought to have said, is they ought to have said, and I don't know if the facts will support this, right? But I'm trying to just say what the court is telling SARS, or what I see the court is telling SARS. SARS should have led evidence to say, with this massive increase in the insurance premium and the taxpayer's explanation that it's self-insurance and an increase in interest income, despite there being no fixed deposit increases or anything, caused me not to go and do my investigation work further. If my systems, like they did in Spur, lead the evidence, my systems are geared to say, if there's an increase in insurance and there's also an increase in interest, we know about these self-insurance things, we don't like them, that would have picked it up. And then we would have identified this issue before and we would have assessed it properly, right? And so therefore, it was the non-disclosure of the interest which materially affected the assessment, because it made me allow a deduction that I shouldn't have. But they must then lead the evidence, even though it's per item, because the court, you'll remember the court does say, even though it's per item, it doesn't mean that you can't then say and argue and prove and lead the evidence that the one thing caused you not to do the other thing. But you can't say by claiming the premium as a deduction it's misrepresentation. It's not. Why? How? Right? That's 92. Right? 99, where's the misrepresentation? I didn't disclose it under repairs and maintenance and cost of sales or somewhere. There's no misrepresentation. Right? But the non-disclosure of the interest, yes, in and of itself, the interest of 2,000 Rand is not material, I grant you. But when you lead the evidence, if you could, if your systems are in fact so geared, right, then you could have said, the non-disclosure of the interest, albeit only 2,000 Rand, that increase in the interest together with the increase in the spike of the premium, if the interest was disclosed, I would have picked it up. And then they could have lifted the veil of prescription. But to say you claim something is not deductible, therefore it's misrepresentation, is nonsense. They seem to be trying to go down initially in their grounds. They say the non-disclosure of the interest caused me not to. Initially, remember when they said in part 1, you can go and listen. In part 1, we said that SARS initially, as a basis for lifting the veil of prescription, said the non-disclosure of the interest caused me not to tax the interest and also caused me to allow the premium as a deduction. It seems like they were on track, and then somewhere along the line the wheels came off and nobody led the evidence to make that link. And in my view, they might have been able to succeed if they could show that. The other important thing that this judgment does on the issue of prescription, and I'll conclude with this in part 2, is where the court looks at the cause of the of the incorrect assessment, the cause of SARS incorrectly allowing this deduction. Remember, because he said that SARS was proved the misconduct and then that the misconduct caused them. The court says, first of all, excuse me, you can't prove the misconduct because you've got no facts to rely on, you've pleaded no facts, and you've led no evidence. And then SARS failed to prove the causation because he says what the auditor, this compliance auditor, when the file was selected for verification before the thing prescribed, the assessment prescribed, the taxpayer told SARS. So if there's a cause of the incorrect assessment, it's certainly not the taxpayer in his return. It is SARS not not dealing with this thing in time. Now this kind of brings up this topic of whether a taxpayer can cure a misconduct. So let's say you misrepresent something in your tax return, right? Let's say you claim something that's clearly not deductible. On your tax return, it's insurance, but you claim it in cost of sales, but it's not, neither of the two. It's not deductible. You're hiding it, right? It's non-disclosure and misrepresentation. And you file the return, right? And then, let's call it a year later, you send SARS randomly, you send them a letter through the post for argument's sake, right? Or formally send them an email. Say, listen, you know what, in that tax return, I made a boo-boo. I claimed something I ought not to have claimed, and I misrepresent something, I'm sorry, can you fix it? And let's say SARS then does nothing, right? And the assessment becomes prescribed. The argument that was put forward here, and indeed in the ABC Trust case, is that conduct by the taxpayer, where the taxpayer now tells SARS about the misconduct, that cures any misrepresentation, so that you can then afterwards say that any cause of the incorrect assessment was not because of any misconduct on the part of the taxpayer, rather it was because SARS didn't do their job before the assessment became prescribed. With respect, and I'm quite critical about the judgment in my book also, with respect, I don't agree with that. I think that kind of defeats to a large extent the purpose. The trouble is with that, and I've said it on the ABC Trust case, I think the reason why you get to that conclusion is because, look, that's what the courts have said, right? I can just give you my views on it, right? So we'll see where it actually ends up. The reason I think the court comes to the conclusion that you can cure it is because the question that's asked when you look at it is the approach to this question is the court says, well, what caused not to assess the taxpayer correctly in the original return and in the 3-year period thereafter? And I think that's the wrong approach to the interpretation of Section 99. The question should simply be, what caused SARS not to tax the taxpayer correctly in the original assessment? Because otherwise, what I can do is I can misrepresent something in the tax return. SARS doesn't pick it up a day before the assessment prescribes. I try and cure it. SARS doesn't do anything about it, and so therefore I've cured it. It doesn't make sense, right? But anyways, that's what the courts have said. Right. So that is effectively part 2, right? And what I think is important to take from this is this submission, and this is the most important thing on prescription, the submission that I can make an audit finding, therefore there's misrepresentation, is not valid. It falls well short, right? We'll see, maybe this goes in appeal, but I think even if it goes in appeal, there's all sorts of issues. Go and read the article I have on Wingate P, is also fascinating. Look out for part 3, we'll go into the merits of this case and deal with this insurance premium and why the court ultimately said that the insurance premium is deductible in 11A, but the taxpayer would have failed on the merits on some other section. And that's important that we discuss that also, and we'll see where this ends, but go and check out part 3.